Hello, I'm Alison Frankel, the legal columnist for Thomson Reuters, and I'm very excited to be here today with Professor Bryan Garner. Welcome, Professor.
Thank you.
Professor Garner is a lawyer, lexicographer, and professor who has written several books about English usage and style, including Garner's Modern American Usage and the Elements of Legal Style. He has served as the editor of Black's Law Dictionary since 1995. He's on his 4th edition, and has co-authored 2 books with U.S. Supreme Court Justice Alison Scalia, Making Your Case, The Art of Persuading Judges, and Reading Law, The Interpretation of Legal Texts. Garner is a distinguished research professor of law at Southern Methodist University's Dedman School of Law, and he's taught more than 2,500 writing workshops since the 1991 founding of his company, Law Prose Incorporated. He also publishes a daily blog with great writing tips at lawprose.org. Black's Law Dictionary, in case you're not aware, is the gold standard, and that's an understatement, for legal dictionaries in the United States. Its namesake comes from its founder, Henry Campbell Black, who published the first edition in 1891. Today, it is the reference of choice for legal briefs, court opinions, and, as we'll discuss later, many Supreme Court decisions as well. I was thinking as I read the prefaces, I noticed that you said that few people do read prefaces to dictionaries. I am one of those people. I was noticing that they come out every 5 years, and I was thinking to myself, I wonder if Bryan ever feels that by the time he gets done rolling the rock up the hill, he has to start all over again from the bottom.
Well, I think it's getting easier and easier because the book is getting better and better. Forgive me, I've got a slight cold, but the book is getting better and better. And a lot of the hard work in terms of getting the core vocabulary for law accurately recorded and well-defined has been done. So now, increasingly, the additions are some of the nuances in the language and some of the more interesting linguistic items, but a little bit more toward the periphery of legal vocabulary. Still important work.
But even the core terms do change, correct? You have to review every time through. You have to make sure that the definitions are still good ones.
Yes, I do. I review everything with every edition, edit every entry. If an entry is really well done, a certain translation of a Latin phrase is probably unlikely to change if it's a short definition. But for me, it's all about phrasing. When I took over Black's Law Dictionary in 1995, one of my stipulations was that I wanted complete editorial control. I wanted to be able to revise all the definitions, re-research them, and I'm really a stickler for phrasing, for good phrasing, and I wanted the definitions to be not only accurate, but really well phrased.
And how many, do you know off the top of your head how many definitions there are in this dictionary?
About 49,000 entries, and probably a multiple of that in terms of definitions. I'm not actually sure about the number of definitions, but about 49,000 entries.
And how many of them at this point would you say, dating back to when you first took over the job, how many of them would you say you have had a hand in changing?
100%.
Wow.
I suppose it might be possible to find a definition that is verbatim from the 6th edition of Black's, but I think it would be very rare.
Wow.
Very rare. So the book's been totally overhauled.
That's really amazing. Do you, when you're setting out on the editorial process with a new edition in mind, however many years it may be until we see another one, do you have a particular agenda? In this edition, for instance, you talked a lot about about going back and doing some additional hunting for Latin phrases?
I discovered that there were many Latin maxims that had been excluded from earlier editions and were historically important. And I wanted to be sure that we had them all. In fact, Black's Law Dictionary already had the finest collection of legal maxims anywhere in print. We had, I think, 3,000. We're now up to 3,900. So it's almost 4,000 Latin maxims in Appendix B. One of the first things I did when I took over the 7th edition was to have all the Latin maxims retranslated by a professor in Glasgow, David Walker, and by another professor at Oxford University, the great Tony Honore. Mm-hmm. And they found, believe it or not, I think it's fair to say, hundreds and hundreds of errors.
Oh my gosh.
In the Latin and in the translations of Latin. Now, it's hard to know where those came from. They could have come from Henry Campbell Black's sources. They might have come from corruptions in the typesetting in 1910, 1933, 1951, because the whole book had to be retypeset, and it was not being typeset by people who knew Latin. I can read Latin, but not at the level of Honore and Walker. And so it was very important to have historians. Honore is a great scholar of Roman law. Walker was the greatest living expert on Scots law, and he died earlier this year. But his contributions, both of their contributions to Black's Law Dictionary, have been tremendous. I'm not encouraging people to use Latin. One of my books is Legal Writing in Plain English. Yeah. I'm all in favor of plain English. But when it comes to being a lexicographer, you want students and lawyers to be able to look up words and find them if they're running across them in historical texts. So I will probably never cut the Latin from Black's. I think it's unwise. The book has a historical bent to it.
And at the same time, though, you added, I think you said 7,500 new words.
It's about that.
Including such unhistorically rooted phrases as affluenza and judge-itis.
Affluenza defense. Judge-itis. I think judge-itis has been used since the 1940s. Judicial diva. Congestion charging. That's a new phenomenon that cities will charge people to go beyond a certain point into the city center.
Yeah.
I think it originated in England, but we have it some in America too.
Can you think of a word that you that was on the edge, on the bubble between slang and something that did need to be included? What didn't make the cut this time around, if you can think of any?
Well, I have a to-do list of over 2,500 terms. And in the final year of completing the 10th edition, I had to engage in a kind of triage and figure out what were of my, let's say, 10,000 terms, what were the ones that we realistically could do justice to, and what were the most important ones. I still have 2,500 more, so we are hard at work all the time. And one reason I think that the frequency of new editions has increased is, it seems like every 5 years since I've taken it over, Black's Law Dictionary, West and Thomson Reuters made the decision to professionalize the lexicography. Mm-hmm. And to have it like all major dictionaries, whether they're Merriam-Webster dictionaries or the Oxford English dictionaries, to make it a professional standard and a constant effort, not to wait 30 years and then, let's cobble together a new version. That's not the way to do a proper dictionary.
Is that why? Now, you pointed out that most of your the sources that you cite are scholars rather than judicial opinions. Is that because you're concerned with the lexicographical integrity of the work?
In some sense, yes. I tried so hard in this 10th edition to quote more cases, and especially more U.S. Supreme Court cases. And I very closely scoured the Supreme Court Reporter, which has, at the beginning of it, words and phrases. Every Supreme Court Reporter volume, that's the Thomson Reuters West publication. I found that the U.S. Supreme Court, like state Supreme Courts and like all courts, federal circuit courts, they are eminently unquotable when it comes to the meaning of legal terms. And I think that's a couple of things. They're usually discussing a term as it appears in one statute only. And right as it starts to get to be an interesting comment on the term, then suddenly it turns sour in the quotation, and it's just not usable. They're very local and often just not insightful commentaries on terms. But I did cite the U.S. Supreme Court, dozens of times in this 10th edition, but not nearly as much as I thought I would be able to. When you have a scholar such as Posner on torts or Charles Allen Wright on federal courts, who has spent a lifetime studying certain doctrines, let's say Wright on certain kinds of preemption, the commentary on the vocabulary is tremendous in those kinds of sources. And that's what I've tried to include. The bibliography in Black's 10th has grown from only 400 or so entries, books that were cited in Black's 9th, to almost 1,000 in Black's 10th.
Wow.
So we've really deepened and broadened the coverage of legal literature.
And in fact, you are a source material for the Supreme Court, so it makes sense that that you wouldn't be able to quote them perhaps as often as they quote you. Is Black's the most cited reference by the Supreme Court?
Probably not by the Supreme Court, but Thomson Reuters supplied me a few years ago with research demonstrating that it is the most widely cited law book in the world. Probably not in the Supreme Court. I'm sure Charles Allen Wright, my mentor, and Arthur Miller, Federal Practice and Procedure, is probably cited more than Black's Law Dictionary. But I was delighted last week to see that Justice Kennedy, in the CTS decision, relied on Black's Law Dictionary as the first authority cited, the first substantive authority cited in the decision on the crucial question of the decision. There was one U.S. Supreme Court case a few years ago that Chief Justice Rehnquist wrote on the meaning of prevailing plaintiff. And we actually cite the case in Black's 10th. But Black's was the only source for the entire decision. And that was quite extraordinary. Justice Ginsburg dissented vehemently, saying this is the only U.S. Supreme Court opinion ever in which Black's Law Dictionary is the only source. She was also, at the time, my closest friend on the court, so I was surprised to see her saying that. But she also dissented in this case, in the CTS case. So apparently Justice Ginsburg, my friend, does not like
cases that turn on
Black's Law Dictionary.
What was interesting to me in the Waldberger case is that we could see the evolution of a definition in Black's, because the case turned on the definition of the statute of repose. And in the 1979 edition, there was a pretty vague definition.
Well, I would actually call that definition not necessarily an evolution of legal understanding of the terms. I think it was actually an inaccurate definition in the 5th edition. They were very kind. The Supreme Court basically rejected the 5th edition and went with the 9th edition.
I do want to turn now to your collaboration with Justice Scalia, which has now extended to 2 books. Can you describe the 2 books and how that came to be?
I didn't really know Justice Scalia in 2006 when I proposed an interview with him, But after 2 meetings, first breakfast and then the interview, we hit it off really well. We just seemed to like each other viscerally, and I proposed that we do a book. The interview was amazing. The interview showed me that he is extremely adept rhetorically and very insightful. And of course I knew that already from his writing style and his opinions. But hearing him on the interview led me to believe that if we could write a book together, it would be unlike any ever done on advocacy. And so, somewhat to my surprise, he accepted. As I think he felt the same way about me that I did about him, at least initially. I thought that he might be a very difficult author, or co-author, given the press that he gets. Because I didn't know the man really well.
Yeah.
But in fact, I found that he's just an amazing co-author. I mean, he's easy to work with. And there were times early on when his pugnacity would take me aback, and I would get an email blasting me about something that I'd written for the book, and I suddenly felt, wow, he really he hits hard, and I suddenly felt as if I know what it feels like to be hit hard by Justice Scalia. But if I had something good coming back, we would work out these problems through a kind of intellectual pugilism, and almost always arrive at a satisfactory, I thought, result. And in fact, he tells audiences that about 80% of the time, when he and I disagreed, he went my way. About 80% of the time. Justice Scalia himself tells audiences that about 80% of the time, when he and I initially disagreed about some point, he would end up going my way.
I think you're probably the only person to have an 80% success rate with...
Well, I would say he's accurate on that. And in the first book, Making Your Case, we had 4 debates. We couldn't quite figure out what to do. We could not agree on 4 points. Sexist language, contractions, citations and footnotes, and no substantive footnotes, those points. And you can easily find them in the book, because in the index there's an entry for Scalia-Garner debates, and it lists all 4. If you look it up under Garner-Scalia debates, it's there too. So it's easy to find where we would argue back and forth. But that was actually a wonderful solution that I don't think I'd ever seen before in a co-authored book.
Yeah, very interesting.
We thought about leaving it out altogether, but I'm glad we didn't.
There was a prominent judge who arose with some criticisms of the book. Of course, I'm talking about Judge Richard Posner of the Seventh Circuit, and this became a bit of a cause célèbre among the legal cognoscenti. Was the Scalia and Garner v. Posner debate. Tell me a little bit about that.
Well, that was very interesting, because I knew that Judge Posner would be our chief intellectual challenge. I had debated Judge Posner before. Judge Posner challenged me to a debate in 2000 on the question of citations and footnotes. We had a debate. It was interesting. That debate, I wrote my essay first. He suggested I go first, and then I got to rebut whatever he said in response. And it appeared in the pages of Court Review. I told him before I wrote, I said, Dick, I'm writing my essay in the hope of persuading you. And I fully expect you to say, although initially I was against Garner on citations and footnotes, he's right, and from now on I'm going to do all my opinions that way. And he wrote back and said, "We'll see." And in fact, that was a pipe dream.
Yeah.
It was a pipe dream. So
I don't think a lot of people changed Judge Posner's mind, but
we had a very lively debate. But the interesting thing about reading law is that I decided early on that my primary reader was Richard Posner.
oh,
And partly what I was trying to do was, this is called, again, a pipe dream. I wanted to overawe him in particular with the historical depth of the book, the amount of prodigious research that went into the book, and the amount of evidence that we amassed in favor of textualism. And I frequently wondered, what will Judge Posner think of this? But I was trying to write the text in such a way that it would be impossible for him to overcome the arguments. And that was the idea. So the ultimate tack that he took, it was not tact. No,
Yeah.
it was not tactful at all. But the ultimate tack that he took in reviewing the book was, frankly, it was a great shock to me. He essentially said the book is riddled with willful distortions of cases and riddled with inaccuracies. But I don't think most lawyers would have no inkling of the degree of fact-checking that we do. Mm-hmm. The degree of fact-checking that I do on Black's Law Dictionary, repeated fact-checking, and repeated, often several different lawyers in my office, again and again over time, verifying the accuracy of every quotation, the accuracy of every discussion, because I have 5 lawyer colleagues, and or at least until recently I had 5. I now have 4 lawyer colleagues. Mm-hmm. And we do an amazingly sort of obsessive amount of fact-checking. Mm-hmm. So to be accused in print of producing a book that was riddled with error was quite a shock.
It was almost worse than had he taken philosophical issue with you.
Well, that's what I expect. I expected that Judge Posner would say, well, they draw on a prodigious number of sources and they cite all kinds of things, but ultimately the whole project of textualism is fundamentally flawed. That was not the attack. The attack was that the whole book was an attempt by Justice Scalia to defend his Heller decision, which was a very strange statement to make, and that it was riddled with distortion and error.
I happen to think Judge Posner has been so influential because he is such a good writer. I think his opinions are so well written and forceful that you end up being carried along on his train of thought, regardless of whether you even intended to board that train or not. How many judges are like that? You must read a lot of opinions.
You know, when I say textualism is the predominant mode of thinking, every judge, virtually every judge in the country says we begin with the words of the statute. Mm-hmm. Justice Breyer says that. Justice Ginsburg says that. Now, some judges say that we begin with the words of the statute and then go far afield from that into all kinds of things that Justice Scalia and I would say are improper. Judge Posner would say that the text is only one of many, many considerations when you're interpreting a text. Hold on, we're interpreting a text. Mm-hmm. So one of his essays a few years ago in Overcoming Law was called, "What Am I, a Potted Plant?" And he basically wrote an essay saying, if you tell me I simply have to decipher the meaning of the statute mm-hmm. and try to apply it to this fact situation, I mean, where's the intellectual fun in that? And I think there's a professorial bent in legal academia that thinks that if we can't debate wise judicial policy, mm-hmm. regardless of of what the statute says, or regardless of what a contract says. And certainly Justice Scalia and I do not even believe that textualism is some easy matter of deciphering meaning and applying it to a situation. That is challenging enough. Mm-hmm. And it's often very difficult. But if that's not what judges are doing, if judges are supposed to be, as Ronald Dworkin said, Hercules, and not think so much about the words of a statute or a contract, but go around or behind the words of the statute and let the statute be what the wisest possible decision would make it be, mm-hmm. Often in contradiction of the words, that's a very different enterprise. Mm-hmm. And that is something that Blackstone warned about, that Washington warned about, that all kinds of great scholars, John Marshall and even Oliver Wendell Holmes, said, I don't care what the legislators meant. All I care is what they said. Mm-hmm. And so textualism has every bit of tradition behind it. It's purposivism and consequentialism. Let's think about the consequences of this and get around the words or behind the words. That is the newfangled theory that really began in the middle of the 20th century. Mm-hmm.
Let's step away from the thorny area of judicial philosophy.
Although I love talking about it.
And talk about judicial prose. You must read dozens of judicial opinions a month. I'm curious to know how many. How good prose stylists are America's judges?
On the whole, not great. Lawyers are not great writers. Judges, on the whole, they're better than lawyers. They tend to be better than lawyers, but it's gotten better. Judicial writing's gotten better. I do a lot of training of judicial writers. I've taught judicial opinion writing now in, I think, 25 states. Oh. And I've taught federal judges a good deal in seminars about judicial writing. Certainly, judicial opinions are better today, much better today, than they were 100 years ago. But they are not as good as they were in the early 19th century. The late 19th century, they started becoming bad. The low point of American judicial writing was probably 1880 to 1920. And anyway, there are some great writers. I think Scalia is one of them. I think that Ginsburg is one of them. Kagan is a tremendous writer.
I was going to ask you about her.
Chief Justice Roberts is a wonderful writer. I wrote an essay a few years ago that I very much regret writing, saying that it was Judge Roberts then, mm-hmm. He was nominated, that I did not think he would go down as a great judicial writer, and I gave him sort of a B+ on the Court of Appeals. And I now think that was quite wrong. I think Chief Justice Roberts is really, he's come into his own as a judicial writer. He is a very keen analyst and writer, and I like Chief Justice Roberts' style. On the circuit courts, I think the leading stylists are Easterbrook, mm-hmm. of the Seventh Circuit, his colleague Diane Wood, mm-hmm. Judge Kaczynski of the Ninth Circuit. I think Judge Bea of the Ninth Circuit is very good, mm-hmm. Carlos Bea. Neil Gorsuch of the Tenth Circuit, Michael Boudin of the First Circuit, Judge Choflat of the 11th Circuit, mm-hmm. is very good. And my own judge, the judge for whom I clerk, Thomas Reevely of the Fifth Circuit, is a wonderful judicial writer. And so those are my favorites probably. I think there are others that I'm omitting. I steal time from sleep, mm-hmm. but I still generally get 8 hours. And what I try to do is to use my waking hours as efficiently as possible. And as a lexicographer, that's not difficult to do. You carry around note cards, you carry around a pad, and I'm constantly noticing things and jotting them down.
It's funny that you mentioned carrying around note cards. That sort of leads me naturally to the age of the computer, and even beyond to the age of the smartphone. Blacks is now online. How has that changed your editorship?
None.
You're not. It's not.
Well, I'm at the mercy of. That sounds wrong. I have no control over the apps that are produced. Mm-hmm. I'm told, however, by everyone who uses the Black's Law Dictionary app, it is wonderful. Mm-hmm. I don't use it myself, believe it or not. I have it on my iPad, I have it on my iPhone, and I just don't use it.
I think
I like the paper.
That kid in the backwards baseball hat in the back row is now checking his phone.
I think he is.
Yeah.
But I'm still glad I wrote it for him. The first pocket edition.
But it's still, the words don't change unless it's not as though today there's a definition that will be tweaked and changed online tomorrow.
No.
Okay. It's still, the 10th edition is set in paper.
For now.
So let's end by talking about the most modern of Bryan Garner editions, which is your Twitter self. You're very active on Twitter, correct?
I am. I tweet every day, virtually, and I try to tweet interesting things. I think it's a fascinating new genre to say something interesting within 140 words.
140 characters.
140 characters. That's right. And so I tweet. Some of them are just quotations that I have collected from various sources that you could not really find online. Mm-hmm. You have to find the old-fashioned way. We don't get sources from online websites usually. We get them from. I get them from books. Mm-hmm. And so I tweet various quotations. I tweet sometimes a little bit about where I am and what I'm doing. But I also tweet whenever I hear grammatical errors on TV. It's a good little outlet.
Must be a lot.
Somebody else tweeted that my coverage of the Olympics was the best of all. But my coverage of the Olympics was simply...
Surely on grammar?
It was the grammar of the commentators. That's right. It was a lot of fun.
I'm sure there was a lot of between her and I.
Yeah, that kind of stuff. Right.
And then there's a school of thought that you have not truly made it until you have a parody. And you do now on Twitter. Some
guy has started an anti-Bryan Garner. I think I must have met this guy. I think he must have gone to my seminars. I don't know who it is. But he is tremendously witty. I love the anti-Bryan Garner, and he's really not anti-Bryan Garner.
No,
he's pro-Bryan Garner.
He's a style prickler also.
But everything he's doing is tongue in cheek.
Yeah.
He's saying the opposite of what I would recommend, and it's hilarious.
Yeah, yeah. Well, thank you so much. This was a very enlightening discussion. I think our Blacks audience will get a lot from it.
Thank you.